Hello and welcome to another Shoosmiths podcast. Today your speakers are myself, Matthew Cole, and Simon McArdle from the Shoosmiths Commercial Litigation Team.
Hello there.
This month we're talking summary judgments. Now I know you're thinking, what's a summary judgment when it's at home? That's why we're here and we're going to tell you what they are. Now, I say summary judgment, but Simon, what do I mean?
You say summary judgment. What you mean is an application to basically bring proceedings to a halt pretty quickly. It's an application where we are asking the court to grant judgment, usually on the basis of a claim form and particulars of claim and defence, without the need to go through every other step that would otherwise happen in the run through to trial. So without the need for disclosure, without the need for witness evidence, without the need for any experts to be troubled, basically we are asking the court to say that the defence, as it currently stands, has got a snowball's chance in hell.
Right, okay. So I want to put in an application. Is there a certain level or a test that the court needs to get over?
The central test or the central concept in relation to summary judgment applications is whether the defence has a real prospect of success. It's ultimately relatively woolly wording around the concept of real prospect, but in essence what you are looking at is that there is a defence that's more than merely arguable and isn't essentially fanciful. What the court will be looking at if it is going down the line of granting a summary judgment application, that there is essentially no prospect and an absence of reality to the response and to the defence.
Right, okay. And obviously, in this instance, we're talking about how a defence has been put in, but it doesn't necessarily go far enough to address the issues, and an applicant wants to apply for a summary judgment. And we were talking over dinner the other night, weren't we, about the case of National Insurance Corporation and Allianz Global Corporate and Specialty AG, which is a 2007 case from
we have some exciting dinners, don't we?
We do. Well, justice and dinner is how we combine the two.
Usually I would be full off just one of those things.
Yeah, I know. I like to go 50-50. And it's in that case, wasn't it, we were saying that the respondent can't just simply leave their statement of case and say that's enough. They need to go further when someone makes an application for a summary judgment.
Yeah, absolutely. You can't just rest on your laurels, irrespective of, as a defendant, what you think about the application and whether you think you've got a decent defence or not. You need to engage with the process in the event that you are faced with an application for summary judgment. Under any circumstances, be that summary judgment or anything else during proceedings, the court will typically take a very dim view of a party that simply doesn't engage and or ignores the other party, as the court may feel that you are ignoring them.
So, I've put in my application, I'm waiting for summary judgment. What type of response or court order can I expect?
Well, essentially the court can do whatever it likes within reason in relation to any application that's made, but you would typically expect it to fall into one of four categories. They'll either agree with you and grant the summary judgment on all or part of the claim. It will, if for instance the claim is for an unspecified sum, however, not for a disputed debt, it may make an order that the proceedings continue on the issue of quantum alone. The third potential order that you may see is simply a dismissal of the application. If it's not with you, if it doesn't feel that you as claimant have established that the defence has no real prospect of success, then it can just dismiss the application. And the fourth is it can make a conditional order, for example, an order that requires a party to pay a sum of money into court and or take some other step in relation to its claim.
Now, obviously we're talking about it in terms of a claimant, but lest we forget that actually defendants can also make an application for summary judgment.
They absolutely can, yeah. If they think the claim has got no real prospect of success, then it's absolutely open to a defendant to make a similar application.
Okay. Let's try a little scenario.
Hit me.
I'm an applicant,
Not
or
literally.
I'm a claimant. I wouldn't. I'd never strike a colleague. I'm a claimant. I've gone through the procedure. I've got back a defence, and I've thought, this is rubbish. This is a pithy defence. This isn't dealing with the issues that I've raised. In general, it's pretty pants.
Is that Latin?
What, pants?
Yeah.
Yeah, it stands for pantai decrei.
Yeah.
It's
legal term.
It's the legal term for insufficient evidence.
Okay.
So feel free to use that, listeners. But what do I do? I've got this. I mean, where do I go now?
Well, where do you go from?
From getting in my defence, it's my pants defence.
I've got pants defence.
And I think,
I'm not happy with it.
I don't want to go through all these stages and spend out all this money on disclosure and statements just to get to the end and they say, no, your defence is pants.
Well, then, I think under those kind of circumstances, my friend, you need to be thinking about summary judgment application. If you are confident in the level of pantsness to the defence, and you're also confident, frankly, that a court will go with you on that, because it's not necessarily just about the merits of the defence. The court can also look at whether there are any other compelling reasons to go to trial. For instance, if it's a particularly complicated matter, or the defendant, in filing their poor defence, has demonstrated that they simply need more time to look into various issues. If it's a relatively complicated matter, then you may find that a court won't go with you. So you do need to be confident of your position, which you should always be with particulars of claim or a defence, but you also need to be confident that it will go over quickly and well to a court. Whenever we're looking at potential summary judgment applications, we are often reminded of some words of wisdom issued by Lord Denning when he was talking about the predecessor to the current summary judgment procedure, and his take on summary judgment as it was then is that if you're still in the hearing after 15 minutes, you've essentially lost. So there is a real key point there that
Denny knew his stuff.
He knew his stuff. He really did. But there needs to be an ability to get the court on side quickly and to find in your favour, because if the application goes on the longer it goes on, then the more complicated by definition the claim is, and the less likely it is that you're going to get home.
Brilliant. Okay. Well, thank you for that. And should you, the listener, wish to find out a bit more about making an application for summary judgment and the relevant points, then please do read the article on Shoosmiths' website entitled "All I Want for Christmas is Summary Judgment." Did you get a summary judgment for Christmas, Simon?
No, just another bike.
Oh, damn it. I had socks and Body Shop vouchers.
Just to drop this in, I know it seems seasonal because of the time of year that the article came out, but it can, of course, apply all year round. So much like dogs, summary judgment is for life, not just for Christmas.
Yeah, that's a good point. And I think, did Denny say that as well?
I don't think that was part of what he said.
I don't think that's part of Denny. Well, thank you for listening, and please do remember to record your time for CPD purposes and read the article if you want to find a bit more information, or please do feel free to contact either myself or Simon. Look out next month for our briefing on Part 36. We look forward to speaking with you then. Bye-bye.